welcome to VIP News Radio. This is hopefully going to be a efficient and effective coverage of U.S. patent laws from the perspective of an examiner. Former examiner examined from 2007 2015 in telecommunications. Fantastic job. Highly recommend it for people with science backgrounds. The examiner is the first line of the process for granting a patent. The examiner grants the patent, of course, but they are the first line, I guess, in the processing of an invention or an idea, because sometimes it will be the case that a patent will end up in court, in litigation, re-exam. In that situation, it can go back to the patent office, to a special unit that handles re-examinations by senior examiners. But the initial examination, there's a core of about 10,000 examiners that examine every invention. Comes through one of 7 or 8 different TCs. Most of the stuff I did were in TC 2100, 2400, 2700, I believe. Computing, telecommunications, cellular inventions, stuff like that. So it's a really fun and cool process. There's actually a lot of tools available. I didn't know this as an examiner because you're in the world where you examiners are guided by several different departments. Of course, there's case law that they have to follow, but then OPLA, Office of Patent Legal Administration, typically will write procedures to handle new cases that come from the CFC or that's the Federal Circuit of the Supreme Court. The Supreme Court, of course, is the court of last resort, or the final say in any case. But not everybody knows that the Supreme Court is those decisions are it's not guaranteed, or it's by choice. It's called a writ of certiorari. I think I pronounced that correctly. It's a Latin term. Anyways, you have to be granted writ. So attorneys that are filing appeals to the Supreme Court have to submit a request for writ, and I think it's something like 1% or 0.1% get accepted. So typically what the court will do is wait for important undecided matters and then handle them frequently in groups of cases together. So if there's the most common one in my area in computing is 101, because software patents are so frequently litigated, or the line between what is patentable and what's not patentable. It's in my art, it's pretty clear in my head. And being a former examiner, it's fairly easy for me. Actually, I would say I should promote my business, Victory Intellectual Property. I have patent agent numbers, and I have Orbit, so I would love to get your search work, filing work, prosecution, stuff like that. I find it very easy to draft an application that will pass 101 because I know what examiners are looking for. Even as the law changes, there's kind of there's sort of a it when you see it kind of thing. So you can draft an application knowing that sort of regardless of which way the law goes, you'll most likely end up with something patentable in there. So that's that. So the main things that an examiner is going to look at, or that you have to pass to get through, to get an allowance, is 35 U.S.C. 101, 102, 103, and 112. This is all Title 35 of the U.S. Code. That's what guides patent law. So any changes to that would have to go through Congress, which typically I like patents because it's a nonpartisan issue. Going into that at the young age of 20, um, patents are typically not politicized, and there's very rarely um, large changes to the law. Um, the America Invents Act um, was passed. The most recent, Leahy Smith, called the AIA, effective in 2012. So that changed a few things. The biggest thing is it made America first to file jurisdiction rather than a first to invent. We were first to file for a long time, and held out on that piece longer than the rest of the world. I think at this point it's debatable as to what effect that had. It got rid of interferences, which would be a proceeding where you have to prove that you invented something prior to somebody else, even if they happen to file before you. So if you filed after, you could still prove with journal, case notes, whatever the situation is, scientific documents that you were first to invent, then you could still be granted the patent on that technology. But now it's first to file, so you have to file first. You still have a 1-year grace period. That's one of the important things, is the grace period actually extends from when you first publish your idea. So, a scientific publication or offers to sell, it's a product, and you make an offer to sell, that would start the 1-year clock from when you have to file. So that's just to say that the AIA passed about 10 years ago now. And that's the biggest one since the Patent Act of 1952. So as an examiner, most of what I was proceeding on is based on the Patent Act of 1952. That set the groundwork. Also, I see here there's some stuff about the PCT, the Patent Cooperation Treaty. If you want, there's no such thing as a world patent. You have to file through the PCT, which grants you the ability within 24 months to file in any PCT cooperating jurisdiction or country. So if you want to go worldwide, you could file in each jurisdiction individually, of course, but filing through the PCT, it buys you more time. You have 2 years to file. It holds your place in the line, basically, and then you can choose which jurisdictions to go into. We call it the national stage in the U.S. when a PCT application enters the national stage. They also will do a search at the PCT. They won't, of course, render a decision under patentability because they're not a patent office, but they will do a search. So anyways, back to U.S. law here. So the main thing examiners look at is 35 U.S.C. 101, 102, 103, and 112. 101 we talked about. That's usefulness, patentability. Your invention has to be either it's PMAC, process, machine, article, manufacture, composition of matter. So composition of matter, chemical compositions, pharmaceutical drugs, stuff like that. Probably the least topic I'm the least familiar with because I have an electrical engineering background. But article of manufacture could be like a widget, a screw or fastener or something like that. And in my art, it would be, we call technologies art. It would be usually like some kind of compact disc or media storage that stores a program. So that's how we satisfy 101 for a computer program, is that it's um, non-transitory computer readable medium comprising instructions which, when executed by a computer, does the following process. And then the next two are process and machine. Machine, fairly obvious. Any kind of machine. In my case, it would be transmitters, cell phones, or like a semiconductor processing machine that makes wafers. So it would be a machine, and then a process would be the process for making something. So as you can see with these four categories, you can have multiple patents on the same thing, so to speak. So you could patent a machine for making a semiconductor wafer, and you can patent the process for making a semiconductor wafer. So that might be confusing to an outsider, but it's the way we draft the claims and the way the claim coverage occurs. So I'll have a little touch here on AI, because there's so much talk about that, and it has a very large effect actually on our business. I think because search is being automated, drafting is even being automated, which is sort of crazy. But I think that, and there's a lot of considerations about like duty to disclose, because we are guided by the IDS, Information Disclosure Statement. For patent agents and attorneys, we're required to notify the PTO of any documents that we know could affect patentability, which is a very broad brush, what could affect patentability. As an examiner, I typically was a little bit more strict about that, so I wouldn't, I would only expect people to indicate things that are directly relevant to the claims. So if it's background art, it's, as an examiner, I knew the background anyways. So I wouldn't need them to file a 10-page IDS. Just file the top 5 to 10 most important references and move on. But in drafting, I've seen the other side, as examiners call it, the private side. They can be very cautious, and maybe even a bit paranoid about citing everything. So if you're using a Wikipedia article to fill in written description, just to give background information about your invention, some people want you to write that in to show that you use Wikipedia, and if it's to protect your license, I guess that makes sense. But as an examiner, I wouldn't really hold someone to that, if it's just helping to fill out the written description. So back to AI. I won't really comment too much on AI-made inventions. I'll say I don't think that there should ever be AI-only inventions. There's a lot of policy reasons for that. As a former examiner, I would say that you certainly can have an idea created by a machine or an AI that would pass the tests 102, 103, and 112 that an examiner would typically apply. So that's sort of to say that an AI could invent something, but there's policy reasons why you would always want a human inventor on that disclosure. And for me, it comes down to the fact that the patent system is for humans, and as searchers, we want a trail of information. So we want that one of the most important things you do when you're examining is you do an inventorship search to see if that inventor has already disclosed something similar that would preempt or prohibit them from getting the new patent because they've already disclosed something that affects patentability. But if you have an AI doing it, and an AI is constantly changing, it's harder to track what the AI is doing. And the AI doesn't know really what's important to an examiner. You can't trust that it's programmed to identify what would be important to an examiner. So I would always want a human sort of swearing off on that application that what the AI has come up with, they either found useful. And and wrote a claim about it. So the question really comes to, at what point did the human invent that? Is it enough just to identify a claim that's new? As a human, I think it may be, because you would already have to be an expert in that art to be able to certify that you find that to be new. So for me, that would be enough. It's a very fine line. To say that the only contribution was that this human identified it as new. And I would find that to be enough, personally. Because the purpose is to encourage innovation. So, as long as you have a human managing their AI and filing applications, and that's enough for me. But having an AI by itself, so there's another reason there to not have AI filing inventions, is because if the AI is let to do it on its own, first thing is you could absolutely flood the patent office. AI has no limits. Of course, it would have to pay, so you could have the AI filing as a small entity and just, bombarding the patent office with inventions. I think it's a bad policy decision. I don't think that encourages innovation. I think that to me, that's where the line is. You can use it, but you have to have a human inventor, would be my case. I've heard some arguments for AI-only inventions where it's a different type of patent. I like that because I like new ideas anyways, but I definitely would want them to be categorized differently. If we have humans who decide that they definitely want to file something, but they definitely do not want to indicate that they are an inventor. In other words, they, as a person, could not swear on the statement for filing. They would have to, if they feel that they have to put the AI down to swear, I think that needs to be in a different category. So it would be examined differently, or at least be held differently. So that's my comments on that. We'll get back to, we have to run through 101, 102, 103, and 112 for this video. So also, I don't think I mentioned that this whole Title 35 USC comes directly from the Constitution. That was one of my favorite things about examining and going straight to the patent office from school, is that you're immediately working in federal law that is directly tied to the Constitution. It's Article 1, Section 8, Clause 8. That's the powers of Congress, and so Section 8 is the powers of Congress, and Clause 8 is Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their writings and discoveries. So that's where copyright and patent law comes from. So back to the laws here. We've covered 101, types of inventions that are patentable. To me, it's almost everything under the sun. 102 is the most important first bar to get past, and that's anticipation. 102 sets forth also the dates. So I'll quote it briefly. I'll use pre-AIA first and then post-AIA, just because I was trained under pre-AIA. So pre-AIA, you have 102A, B, and E were the most relevant ones as an examiner. 102A is that you're entitled to the patent unless A, the invention was known or used by others, or patented or described in a print publication for the invention thereof. And B is the invention was patented or described in a print publication or in public use or on sale more than 1 year prior to the date of application. So that's the 102 bar with the grace period. And then E, the invention was described in an application for patent or patent granted. So that's whether it was filed prior. So A, known or used by others in this country, or patent or described in a print publication in this or foreign country before the invention. B, invention was patented or described in a print publication in this or foreign country or in public use or on sale in this country more than 1 year prior to the application. Now that's been changed to, under the AIA, which is now first to invent, you have 102A, which is novelty and prior art, and 102B, which are the exceptions. So old 102A and B have sort of become 102A1, and 102E has become, old 102E has become new 102A2. So 102A1 is the claimed invention was patented, described in a printed publication or in public use, on sale, or otherwise available to the public before the effective filing date of the claimed invention. So that kind of covers old A and B. So whether the claimed invention was patented, described in a printed publication, or in public use, on sale, or otherwise available to the public before the effective filing date. So that covers everything. And then 102A2 is the claimed invention was described in a patent issued under Section 151, or an application for patent published or deemed published under Section 122B, in which the patent or application names another inventor and was effectively filed before the effective filing date of the claimed invention. That's basically old 102E. So it was filed prior, even though it maybe hasn't issued yet. But it has published, and it names somebody else. We call it the inventive entity. The inventive entity is the assignee, the owner of the patent, and then the inventors. I believe that's the entire inventive entity. So if the inventive entity is different on something that was filed before your claimed invention, then under 102A2, you could have anticipation. And then 102B are the exceptions. So I'll use my little chart here. The exceptions under 102A1 are 102B1, A, and B. So disclosures made 102B1 are disclosures made 1 year or less before the effective filing date. If their disclosure made 1 year or less for the effective filing date, it shall not be considered prior art under A1 if A, the disclosure was made by the inventor or joint inventor or by another who obtained the subject matter disclosed directly or indirectly from the inventor or joint inventor, or B, the subject matter disclosed had before such disclosure been publicly disclosed by the inventor or joint inventor or another who obtained the subject matter disclosed directly or indirectly from the inventor or joint inventor. So that's to say that if the prior art being used was from that inventor and it was within 1 year of filing the patent application, then that piece of prior art cannot be used in an anticipation or even an obviousness rejection. It can't be used. So when we get to 103, that's obviousness, which is generally combining multiple references or a single reference with inherency. It's to say that even though the invention is new under 102 or novel, hasn't been disclosed anywhere, so it passes 102 novelty, it still would have been obvious. And I found later in my career that almost everything to me revolved around obviousness, because at first, when you're in a new art, and you get to know the art really well, it seems like there's a 102 for almost everything. I think earlier in my career I did more 102s, because if you get to be an expert at claim language, you can, the purpose of a claim, actually sort of touched on this earlier, I think the biggest, one of the biggest skills that a patent practitioner has is drafting claim language. I would say it's probably the most important. So those of us who have been doing this for a while would be willing to outsource searching, and then after you become an expert, even drafting. So heads of these bigger patent practices typically will have a lot of people, agents and engineers, drafting underneath of them. And then a lot of it comes down to claim construction, invalidity, handling, licensing, of course, handling enforcement of a patent. So if they're trying to find evidence of use by a competitor who hasn't licensed the technology and then suing them in federal court, you're sort of leading IP attorneys will be managing that. What did they used to call them? The headline or the marquee. Most of these patent places will be Avalon Spivak or something like that. Baker Botts. So these headlining attorneys will be looking, I think, at defense and enforcement. And it's not to say that they won't do some drafting, but this is going back to claim language. That's the most important thing, I think. Claim construction is one of the most important things that a seasoned practitioner will be good at, and would really never trust an AI to do. Because they would always want to tweak it themselves, regardless of what the AI came up with in a drafting situation. Claim language is so important. So going back to applying 102 as a younger examiner, the claims these practitioners are trying, your skill is to cover the invention as broadly as possible. So if you have, a new fastener, say it's some kind of serrated nail, perhaps, so that it's difficult to, retract from a piece of material, wood or something. So you would claim, I claim fastener comprised of metal having a certain length with serrated edges along the length, and that's it. So you would try to cover every instance of that, and then the examiner is going to come back with perhaps a screw and say, well, you could nail this screw into the wood, and that's the same thing. So then the applicant would have to say, well, my serrations are only on one edge. So the claim would now say, having serrations on one edge, and perhaps have negative limitations saying that they are not on the other edge. Claim construction can get very complicated. So the examiner would come back and either try to say it's obvious or try to come up with another patent, prior art. But that's just a simple example. Covering 102 here. So that's anticipation. So 102 sets forth what is anticipation. And as I was saying, as an early examiner, it seems like everything that they're claiming I can find in another application. So in my case, it was telecommunications type stuff, packet processing, routing. I know the layers that stack by mind, application, presentation, session, transport, network, data link, physical. So really most of my stuff was from session, network, data link, and some physical. So not a lot of application and presentation. But yeah, session transport. Session was like session initiation protocol. Transport would be TCP, IP, or UDP. I'm sorry, UDP, and TCP, and then network would be like IP protocols, data link, perhaps Ethernet. And that would also set forth some physical layer stuff. Physical layer could be modulation, things like that. um, handling of um, MIMO processing, multiple um, streams of data. So, anyways, back to 102. So, I think it seemed like a lot of the language that I saw early on would fit into anticipation, but I think as you get to know the art really well and you get to know its searching really well in a specific art, as I did, you could pretty much clear out 102s very quickly and know that something was novel just from your own experience. You almost become an expert in the art, where the USPTO standard is to be one of ordinary skill. So would one of having ordinary skill in the art identify this as being anticipated or obvious? So faceta, person having ordinary skill in the art. But I think there's a good argument that examiners become experts. So there's some examiners with very low allowance rates that I would potentially argue that they're experts at that point, and they might be a little bit not allowing as much because they sort of would perhaps make combinations that are a little bit more complex, or they would draw a harder line on what would be patentable, looking at the prior art. And I think one of the best arguments about that would be hindsight reconstruction, because a lot of inventions, it looks obvious once you see it described to you. So similar to that serrated nail that I just described, would seem obvious when someone describes it, but until that person came up with it, was that obvious? What are some other patents? I think the Squatty Potty was one. I like to look at Shark Tank type stuff. That was granted a patent, and perhaps it seems obvious in hindsight. But I think it was worth a patent. So that's an argument that would have to be made between the examiner and the applicant. So continuing on 102 and now trying to move over to 103. 103 is obviousness, and that's to say that even though we've determined that there isn't a novelty argument, or there isn't a 102 anticipation reference out there, the invention would still be obvious based on either inherency, or they'll take official notice about certain things being obvious, or they'll combine references and say the combination of these references. So later on in my career, I got to be very shrewd at eliminating 102s and very good at searching and understanding claim construction. But it seemed like almost everything, there's a way to apply a 103. So the line to me became, and my allowance rate, by the way, was somewhere around 67%. So I was sort of in the middle. And there are examiners up around 80 to 90% allowance rate, and there are some down around 20, 30. So I think 67% is fairly reasonable. But I knew tough examiners. I knew very easy examiners, and when I was there, I would think of that as sort of being loose in terms of being a rubber stamper, or perhaps being too tough and not letting enough stuff go. But now I kind of look at it as like that one single number can't indicate necessarily. I think what I'm saying is the number can't indicate the strength of the patent, because people with high allowance rates could be getting to allowable subject matter a lot faster. Something that I hadn't thought of until I was on the other side. If you have a 90% allowance examiner, they could be getting through the 102s quickly, identifying material that's allowable very quickly, and indicating that to the applicant, or at least not rejecting that material, which is kind of an implicit indication. So those patents could be just as strong, this is to say. So when I was an examiner, I felt that there was sort of a prestige in being a tougher examiner, because they kind of knew everything, and they're trying to prove themselves. So I had that strategy for a little while, was to sort of prove yourself And I think in the academy, there's a little bit, or at least there was, I don't know what it's like now. Um, I try to stay in touch with them to some extent. It's been a long time. It's been 7 years since I've been there, 8 years almost now. Um, but there was a little bit of you have to sharpen your teeth and you have to be able to show that you know all different types of rejections while you're a junior examiner. And then once you become a primary, you can really make your own decisions because you're trusted to know the art at that point. Um, so I think it would have been really fun to become a primary. I was close. I was a 13, but I have plenty of friends there who are primaries. And like I said, some who are easy, some who are hard, but the easier ones, um, I wouldn't indicate those patents as being any weaker. They could just be identifying stuff much faster. Um, and then those examiners with lower allowance rates, they could be really restricting innovation because they are refusing to indicate stuff that should be allowable, and then applications are becoming abandoned because the applicant is never getting to that material that is allowable. So that's an argument that I hadn't really heard, that I came up with. Um, Another thing about that too, though, on that topic, what I've thought about I've kept a listing of all the patents that I prosecuted, ones that were allowed and the ones that were abandoned, and the number is about the same, over 100 of each. Of course, there were patents when I left that were unprosecuted, that had not finished prosecution, so I don't know how they turned out. There were maybe, I don't know, 50 to 80 on my docket. But the 100 plus allowances and abandonments, there could have been allowable material in those abandonments that we just never got to. So that's something that examiners don't always think about, or quote unquote tough examiners. But I definitely stand by those allowances. I would say I was a very, very strict, tough searcher. I applied a lot of references. And those cases that I allowed, I would stand by very strongly. So that's still completing this sort of transition from 102 to 103. So 102 being anticipation, and then 103 being obviousness. And 103, the most basic kind of inquiry that you're doing with the claim language is called the Graham v. Deere factual inquiries. There's 4 of them. This is a case from 1965. So you have examiners taking these steps for each claim that they are examining. One is determining the scope and content of the prior art. So that's what you know inherently by already examining in that art. And then also searching that application. So that's the scope and content of the prior art. So things that have happened before that invention and things that have been patented or published before that invention. Number 2 is the level of skill of a person of ordinary skill in the art. I think that's kind of tougher to decide, but as I said, an examiner becomes a person of ordinary skill in the art, or they are sort of the test for a level of ordinary skill in the art. They have to make that determination. And then number 3 is the differences between the claimed invention and the teachings of the prior art. So that is probably the most important part of the factual inquiry. So what's the difference between this claimed invention and the teachings of the prior art references? So number 4 is the extent of any objective indicia of non-obviousness. So those are generally 132 declarations, unexpected results, commercial success, long felt but unsolved needs, and the failure of others in the same endeavor. So it doesn't really cover how you would combine multiple references, but item number 3, or inquiry number 3, the differences between the claimed invention and the teachings of the prior art, really is about, if this prior art teachings don't provide an anticipation argument or anticipation rejection, then what are the differences between the claimed invention and the prior art? And would those differences have been obvious anyways? So the examiner could use official notice to say that those differences would have been obvious just based on their own knowledge of the skill of ordinary art. So with our nail example, the examiner could just say, I take official notice that it would be obvious to take a screw and shave the edges off of 3 sides in order to have a nail with one-sided serrations, and just say that, and I would argue that back, of course, and say that wasn't obvious as the practitioner. So that would be the differences between the claimed invention and the prior art. And they could also combine a reference. So they could take a regular nail, a patent or a publication of a regular nail, and then they could take a publication for a serrated knife. This is what I think was the questions that confounded me the most as an examiner is, when can you do that? How often can you do it? When is it truly correct to do that? And when is it not? So I was really determining what is a level of ordinary skill in the art to make these combinations. And again, we would make them very enthusiastically as an examiner, because you have the power of the patent office behind you. And you're, if you're an examiner with partial sig, then you get to make those determinations. But as a practitioner, I'm more strict and argue against a lot of combinations. So sometimes I like to go back to my cases and see how I would have argued them from the other side. But anyways, back to the number 3 and our serrated nail example. The examiner could say, even though he doesn't have a single reference with the serrated nail, he takes a nail and a knife with serrations and says, well, it would be obvious to combine these, take the serrations off of the knife, put them onto the nail, and know that now you can make a nail that's more difficult to remove from the material in which it is fastened. So that's sort of a little bit of a window into 103. And of course, your expert attorneys will use a lot of magic and case art and stuff like that to argue for or against those combinations. So, and I would see this a lot in searching. I search for some of the best companies out there. Landon IP, very good search practice. Now been acquired by CPA Global. My favorite tool that I use is Orbit. So again, a little promo for work that we do here. Send us search work. I love searching. Love using Orbit. It's very fun, very informative for inventors. So we can do the search work for you. Going back to 103, 102, a attorney defending a patent in court will be saying that it wouldn't be, these references don't anticipate or wouldn't render obvious the claimed invention, and the attorney trying to invalidate that patent, perhaps if the two parties couldn't come to a licensing agreement, the attorney invalidating it would be doing a search, coming up with the references and saying it would have been obvious, or this invention is already anticipated, and this patent should be invalidated or not, held not enforceable. So you can be on both sides of that issue, and you have to understand the contours very well to do that. So that's a good initial coverage of patent law and what it takes to search and come up with an idea and file. Again, contact us. I use VIP News Radio. I like this as a publication. We want to do a lot of good things for people. I'm hoping to do First Responder Fridays because I want to find a way to encourage innovation in the first responder community. So we'll try to get that rolling. If you have any search work, we can do that. We're not conflicted out. prosecution work also can do that too. We'll have to clear conflicts, but looking for that work, and can definitely help with that stuff. Have a lot of background knowledge of it, have a lot of experience with it. So that's it for today. Thank you for listening. Please distribute the video and like and subscribe, and happy inventing.